Thank you, Mr. Chairman. Judge, welcome.
Thank you.
I have to say, in the past year, we've seen a pattern of judicial nominees from President Biden, where over and over again, nominees have records of being partisan and ideological extremists, rather than men and women committed to following the rule of law. And looking at your record, I'm concerned that this nomination follows that pattern. You have had predictably knee-jerk left-wing views on the Second Amendment, on immigration, on the death penalty, on crime. I want to start with the latter. On the death penalty, you oppose the death penalty.
Senator, I've never had a, well, let me say this, before I became a judge, I never indicated any view regarding the constitutionality of the death penalty. As a sitting judge, I have had capital eligible cases. There were not seeks of death in those cases. I was fully prepared to apply the law in those cases, and the death penalty is constitutional. I would apply any Supreme Court and Second Circuit precedent.
So, but you've spent, what, 10 years as a federal judge? Have you imposed the death penalty in any case?
I have never had, I've had cases that were death eligible, and you know the process involves the local office and Maine Justice determining whether or not to seek the death penalty. The death penalty has never been sought in any of the cases over which I've presided. That process takes time, so I have presided over cases that were death eligible.
We've got limited time, so you have not imposed the death penalty in any case you presided on, correct?
It would have been unlawful for me to do so. That's correct. No case.
So let me start with my initial question. You oppose the death penalty?
Senator, I don't have a view that could be expressed, and I can.
You don't have a view. You spent years litigating. Let's say you led an amicus brief in Bays versus Reese, trying to challenge the death penalty. You participated in a Supreme Court panel in 2007 discussing Bays, and you also discussed Kennedy versus Louisiana. That happens to be a case I know well. I argued Kennedy versus Louisiana. It dealt with a truly horrific crime of a 300-pound man who brutally raped his 8-year-old stepdaughter, so much so that it left permanent, serious injuries to that young girl. Your notes for the panel at the time said, but the actual question and issue has nothing to do with innocence. If you have consistently litigated against the death penalty prior to your time as a judge, and yet you're not going to answer whether you oppose the death penalty or not?
Senator, my personal views have nothing to do with my application.
You didn't say, you said you didn't have a view. You may disagree that your personal views are relevant, but that's not the same thing as not having one. I mean, we're adults here. You oppose the death penalty.
Senator,
that's okay. That is a view people can have.
Senator, I can assure you, in any death case before me,
okay, but you're not going to answer the question. But there's a difference. You can argue your personal views are irrelevant, but you're just refusing to tell them that. Well, let's shift to criminal justice generally. The Biden administration keeps nominating radicals when it comes to criminal justice. 2 of the senior officials of the Department of Justice are among the leading advocates for abolishing the police. The U.S. Attorney now in the District of Massachusetts, as a prosecutor, put out a list of 15 crimes she would not prosecute. And as I look at your record, you have a pattern on so-called compassionate release of releasing violent criminals. So, for example, in United States versus Stephen, the defendant had been indicted in part of what the Department of Justice called, quote, the largest gang takedown in New York City history. The defendant was one of 120 members of rival street gangs that were busted for racketeering, narcotics, firearms offenses. He was later arrested for violating the terms of his supervised release. Last year, you set him free, and that was bad judgment. And what's remarkable is that you released this criminal without even waiting to hear from the government whether he was a threat to society. In fact, the government planned to present you with substantial evidence from video surveillance footage and testimony from 2 law enforcement officers that he was unlawfully carrying a firearm and so was a threat to society. Why did you release a violent criminal without even waiting to hear from the prosecution about whether he was a risk to the community?
Senator Cruz, I have had many cases during the pandemic, as all judges have, regarding compassionate release in each of them. And actually, I think that was not a compassionate release case, if I recall correctly, but forgive me, I'm not sure. In each of those cases, I have analyzed the factors under First Step Act and 18 U.S.C. Section 3553A. By and large, the majority of cases, compassionate release was denied.
Okay, let me try again because my time has expired. If you would answer the question I asked you, which is why did you release this violent criminal without even waiting to hear what the prosecution had to say about whether he was a threat to the community?
Senator, I don't have a memory of that procedural posture. I have to say, my practice, of course, is to hear from both sides before issuing decisions, either in writing or orally. So as I sit here, I don't know what you're referencing.
Thank you.
Senator Lee, Senator Blackburn.
Thank you, Mr. Chairman, and Judge, thank you for your time. Senator Grassley asked you about the Second Amendment, and you said that you agreed it was a fundamental right, correct?
Yes, the Supreme Court held that it is a fundamental right.
So in that light, do you believe that the Second Amendment should be held with the same seriousness as the First Amendment?
Yes, Senator, constitutional rights must all be respected and implemented in accordance with Supreme Court and, in my case, Second Circuit precedent. Okay.
So you have no concerns about Second Amendment rights for the individual?
Senator, I have no concerns about applying Supreme Court and Second Circuit precedent in this area or any other.
Okay. I have to tell you, there are a lot of Tennesseans who are very concerned about some of the judges and the nominees that are being brought forward by this administration, because there seems to be a tendency to pick and choose what rights you want to say, I agree, in the text for this one, but not for that one. And so it's important to Tennesseans. Let me ask you about your judicial philosophy, both in terms of statutory interpretation and constitutional interpretation on that. How would you define judicial activism when it comes to some of these decisions? And how would you address the concerns that Tennesseans have about this subjectiveness that some of the nominees are bringing forward in their comments to us?
Senator Blackburn, on the question of the meaning of judicial activism, I think, of course, that could mean different things to different people, but I think the pejorative meaning, the meaning that people are concerned about, would be some notion of a judge substituting his or her own policy or personal views in the course of the function of judicial decision-making, whether it's interpreting the Constitution or statutory provisions or otherwise. If that's the meaning that folks are concerned about, and I suspect it is, there's no role for that.
Well, let me move on to political activism, because you've been very politically active in your career. 2004, you served as Associate National Counsel to presidential candidate John Kerry. You served on the Obama administration DOJ transition team, the Obama-Biden campaign for change. You served as a volunteer lawyer for the Maryland Democratic Party. All of those are correct, right? And also for the Democrat National Committee.
I'm not, the Maryland Democratic Party, I'm not.
Yeah, you served as a volunteer lawyer for the Maryland Democratic Party and the DNC. So let me ask you this. When litigants appear before you, how do they know that you are not going to exercise some of your political activism as you look at their case?
Senator Blackburn, I've been a judge for about a decade now. I gave up my prior role as a government lawyer, as an academic, as a lawyer in private practice, and my volunteer work that I had done on a variety of campaigns. Like a lot of judges who come before me, that was part of my prior career. I gave that up.
Okay. Your release of some felons during the COVID-19 pandemic, and I've been watching the hearing up in my office. I don't think anyone has asked you about this, but several of those that you exercised compassionate release for, they were violent criminals with violent histories. In some of the cases, the criminals had already been vaccinated or had already contracted and recovered from the virus, or their prisons had no confirmed cases of COVID. Recently, there has been an increase in violent crime and highly visible smash and grab robberies that are just plaguing so many of our cities. And releasing violent criminals will only further endanger our communities. And so I would like to hear your justification for this decision to release violent criminals and to say this is a compassionate release, because I know retailers don't see this as compassion, and communities, a lot of security moms don't see this as compassion.
Senator Blackburn, I had, like many judges during the pandemic, many petitions, requests for compassionate release. By and large, I denied those, and where I did deny them, it was largely on the fact that I, under the relevant statutory factors, determined that the individual was likely to be a future danger. And the instances in which I didn't, I evaluated the factors under 18 U.S.C. Section 3553 and in conjunction with the compassionate release.
Sao nhớ thương đầy vơi, mộng tình còn trong tim hay chết theo ngày tháng, còn mãi nhớ hôm nào lời chào nhau ban đầu, ai nỡ quên tình nhau. Đời còn gì vui hơn trong phút giây được yêu, đời còn gì đau thương khi lắng nghe tình vỡ. Vì đã chót yêu rồi thì xin ghi đôi lời, dù xa cách phương trời. Ôi bao năm đã cách biệt, anh ra đi vì đất Việt, thì dù xa xôi em nhớ rằng đừng tối sầu, làng thôn êm ấm lúc anh về đẹp tình nhau. Vài lời gửi cho anh em viết nên bài ca, kỷ niệm một đêm mưa, đêm cuối 3 ngày phép, ngồi thức suốt canh dài, thầm ghi câu sum vầy lòng thương nhớ vơi. tình còn trong tim hay chết theo ngày tháng, còn mãi nhớ hôm nào lời chào nhau ban đầu, ai nỡ quên tình nhau. Đời còn gì vui hơn trong phút giây được yêu, đời còn gì đau thương khi lắng nghe tình vỡ. Vì đã chót yêu rồi thì xin ghi đôi lời, dù xa cách phương trời. Ôi bao năm đã cách biệt, anh ra đi vì đất Việt, thì dù xa xôi em nhớ rằng đừng tối sầu. Làng thôn êm ấm lúc anh về đẹp tình nhau. Vài lời gửi cho anh em viết nên bài ca, kỷ niệm một đêm mưa, đêm cuối 3 ngày phép